Thank you, Mr. Chairman, and welcome back to September. Arbitration gives consumers a simpler, cheaper, and faster path to justice than does the judicial system. That is what the evidence showed in the last time the Judiciary Committee performed oversights of the arbitration system during the 111th Congress. That is what the evidence showed earlier this term when we renewed that oversight in the Subcommittee on Antitrust, Commercial Law, and Administrative Law. In fact, the evidence in favor of preserving access to arbitration has only increased over time. Companies are continuing to improve the fairness of arbitration agreements and have long been following improved arbitration protocols to help assure due process is given to claimants against them. The market has resolved problems in the consumer credit arbitration considered during the 110th and 111th Congress, and a string of new Supreme Court decisions has demonstrated the court's confidence in the arbitration system. Even the Consumer Financial Protection Bureau's 2015 arbitration study highlighted problems consumers would face if they had no access to arbitration, but instead had to only rely on flawed judicial class actions. The study emphasized the rise of pre-dispute mandatory binding arbitration agreements in the consumer settings did not come out of nowhere. It stems directly from the repeated abuses of class actions that have plagued the judicial system in recent decades. That is not to say the arbitration system is perfect, but the arbitration system is generally good and should be preserved. Unfortunately, that is not what the Forced Arbitration and Justice Repeal Act would do. Rather than preserve and strengthen arbitration, it would wipe it out for enormous numbers of consumers and employment disputes, as well as many civil rights and antitrust disputes. What that would do is not end injustice, but it actually would promote injustice. In far too many cases where everyday consumers and employees are denied rights to arbitrate, rights that their contract guarantees them to, it means that they will be shut out of the judicial system entirely. If their claims are small enough, they can go to small claims court. That may be an option. But in 46 states in the District of Columbia, small claims courts only take claims worth $10,000 or more, or $10,000 or less. 30 of those jurisdictions, limits are set at $5,000 or less. Millions of claimants with case worth amounts not much higher than those ceilings will never be able to pay courtroom lawyers enough to take care of their cases in ordinary trial courts. Maybe if the claimants could qualify as plaintiffs in a class action lawsuit, they could join in those cases. Millions of people, however, will not be able to do so. Even those who join a class action lawsuit often expect to get nothing in return but a postcard telling them they've won a few dollars and cents on a coupon. Meanwhile, the class action plaintiff trial lawyers will reap multi-million-dollar shares in fees from the recoveries they dole out to plaintiff's case members at mere pennies on the dollar. If you ask me, it would be better to call this bill the Forced Class Action and Justice Guarantee Act. Rather than wipe out arbitration, we should be considering ways to make it better. And while we do that, we should do everything we can to reform all the abuses out of the class action system. Senate Judiciary Committee Chairman Graham suggested that we do just that at the Senate Judiciary Committee's hearing on the arbitration earlier this year. He was exactly right. The worst result Congress could deliver for the American people would be to wipe out their access to arbitration while leaving them no alternative but an unreformed judicial system. It is amazing to me, again, coming forth with a bill on something that we could probably find some common ground. Instead of going to those grounds, we go to something that really is, again, an overreach that does not need to happen and will actually penalize many people in the process. Before I close, Mr. Chairman, I'd like that the letter from the National Association of Home Builders, the Institute for Legal Reform, National Retail Federation, and the Consumer Banking Association be entered into the record.
Without objection.
And with that, I yield back.